Helen and Julie, did Jane make y'all aware that they amended the complaint in her case yet again?
No, she hasn't told me anything about them re-amending it. No.
Yep. Now they've gone back to doing it the way it was done the second time they amended it.
When did they
I'm
do
sorry,
that?
the first time they amended it.
When did they do that?
According to this, the 31st of October.
Why would they do that?
They're trying to delay taking her to court. The deal here is the municipal attorney knows they don't have a fucking case. Okay? That's what's going to get her ass reamed so hard when this is over. Because she's prolonged this without good cause, knowing damn well there's no offense to prosecute. So she keeps changing the complaint to make it look like they're having problems figuring out how to charge her. But the thing about it is, we keep arguing that they do it wrong each and every time. She knows we're right. All she does is say it complies with what used to be 45.08, which is now 45A point whatever the hell it is.
So basically, she's trying to cover her ass for her mistake.
No, what she's trying to do is draw it out long enough to frustrate Jane so Jane will give up.
Give up? Oh, well, that ain't going to work.
Okay? And this is one of their favorite tactics to use.
Yep.
So they delay till you get tired of it and just say, let's get this over with. I'm tired of having to come to court.
Yeah, just let me make a deal and be done. Yeah, no.
But here's their problem. Every time and that document I just gave y'all a copy of explains why it's a problem. But what they're doing is using these docket calls to summon you to court. The problem is there is nothing in law that allows them to summon you for that. There is a specific list of things they can cause you to appear in court for that are codified within different parts of the statutes of the Code of Criminal Procedure, all of which are documented in that document I just gave y'all. But if it's not on that list, they cannot summon you to court for it legitimately. Or they cannot force you to appear to court for it legitimately. Okay? And we'll go over part of what's in there. But this docket call has multiple due process issues with it. First and foremost, it's designed to inconvenience and harass the accused. That's the only reason it's being done. That's one of their tactics to make you want to give up, especially if you live 2 or 3 or 4 hours away from their court.
Yep.
Okay? The problem is it's illegal for them to do it, at least in the state of Texas. So, one of the ways we can go after them for doing it is to use the exact same laws they wrote to combat the liens and summonses and warrants being issued by the morons that were in the Republic of Texas situation. They kept convening their own little private courts and their private sheriffs and their private warrant process servers and their private cops to go out and arrest these public officials or issue warrants for these public officials. And so the state legislature created laws specifically to combat those types of activities. But the way it's written, they can be used against anyone that engages in that activity, including these justice and municipal courts. One of those statutes is simulating legal process under the Penal Code. That statute was written specifically to combat the Republic of Texas arrest warrants and summonses and subpoenas. Well, if a court, even though it's a legitimate court, is issuing a fraudulent summons that it has no legal authority to issue, they are engaged in exactly the same activity as those people in the Republic of Texas were. So we can go after them the exact same way that they would go after the Republic of Texas people. We can file criminal charges on them.
Did you see where there's been some constitutional changes? And one of them was to the way the Texas judicial conduct.
Well, those can't be constitutional changes unless
Well,
there was
they
a
made some
referendum to the
changes.
public to
Yeah.
vote on it.
Or they made some amendments that the people just voted on Tuesday night. And one of them was about the Judicial Conduct Committee. So I think they added another citizen to that committee in their change. Have you read that?
I didn't even know it was on the agenda.
Yeah,
That's the problem looking at the other shit in front of me all day long and not
I'm
having
sure.
time to go look at news.
But just have a look at it through your, just even your local news station online. They have it all up, posted up there, especially KHOU has it up there.
Okay. All right. Well, real quick, this is the new complaint that they just issued on the 31st of October in Jane's case. So this is what they've got now. I, the undersigned affiant, do solemnly swear that I have good reason to believe and do believe that based upon a report to me by Natalie Grimaldo Delgado, Animal Control Officer, who observed or investigated that one Jane Gray Lynch on or about the 10th day of March 2025 and before the making and filing of this complaint committed the following offense within the territorial limits of the city of Irving, Texas. Did intentionally feed an animal or made food available for animal consumption in a manner that creates a danger to public health or safety in violation of 6-80E1 City of Irving Code of Criminal and Civil Ordinances. Okay? Now, I got more emails from Jane about what they're liable to try and testify to and other videos or photos or anything like that they may try to introduce at trial. And I tried to get her to understand that they can't introduce anything at trial they didn't provide you in discovery. If they do, then they're in violation of discovery. And you can have it excluded for the fact that it was not given to you in discovery. And then you can ask for sanctions against the prosecutor for pulling that underhanded bullshit.
Yeah, ambush prosecution.
Well, no, it's just a straight up violation of the rules of evidence.
Yeah.
They are required to deliver everything that they intend to use or that could be exculpatory to the defense when discovery is made. No exceptions. They don't get to pick and choose whether or not they want to give it to you. If they intend to use it or it is in any way exculpatory, they must give it to the defense. Period. Yep. So if they didn't do that, they cannot come back and try to introduce something else at trial to use as incriminating evidence. The only way that could happen is if they declared that they just became aware of it and that it was relevant to the specific issue at hand. Well, if they're trying to show something that they've seen at other dates and times, then it's not relevant to the specific issue at hand. Right now, they have set this up where they are limited to only what occurred on the 10th day of March 2025. And the video and the statement related to what occurred on the 10th day of March of 2025. That's the only thing they can use. So I told Jane to stop worrying about this other crap because all she has to do is object to it as not being relevant to the current case and was not something provided in discovery for this case. Therefore, it is barred.
Mm-hmm.
But Jane is one that's extremely difficult to get focused on anything without a cattle prod. So, we'll see if I was successful in getting her to do what she needed to do and go back to looking at the issues. Now, let me show you guys something here. This is the ordinance And this first page is the only one that contains anything about this ordinance we need to be aware of. Absolutely nothing else in this ordinance matters. This first paragraph and everything listed down here in E. Okay? That's it. That, ladies and gentlemen, are your specific fact element issues.
Yep.
There's nothing else to be looking at. Nothing.
Yep.
Now let me explain something to you that little 13-page document I gave you doesn't cover. This is the stuff they teach the attorneys in law school about procedure, and until you go sit and watch how it plays out in court, you're not going to understand how this works and why. Okay? But the reason it's good for you to go and observe court cases whenever you can is you get to see how the prosecutor must present their case. And since our witnesses are actually the state's witnesses, we want them to have as much information in the record as possible for us to attack, provided it's information that is relevant and necessary to them to prove the case. If it's anything other than that, we must be objecting to it and preventing it from getting into the record.
Absolutely.
Otherwise, we want the prosecutor to handle all the menial details for us. And guess what? They have to handle the menial details for us. Why? Because the first thing the prosecution must do is establish the credibility of their witness. If their witness isn't credible, their testimony is worthless. So the prosecutor is the one that has to ask all the questions, that lays all the foundational groundwork for the officer's training, the officer's education, the officer's ability, what the officer knew, what the officer saw, when they saw it, how they came to have knowledge of it, etc., etc., etc. All we have to do is pay attention to the way the questions are being asked, object when necessary, when the question is inappropriate or does something it shouldn't, such as leads the witness, or allows or makes prejudicial statements, or allows prejudicial responses. Otherwise, we want to let them present their case to lay the foundation we need to attack their witness. In this particular case, that's going to be extremely easy. Now, it's not going to always be this easy, believe me. Okay? But that's the process. They will give you what you need to build your foundation on, as long as you make sure and make your notes of the questions they ask, so that you know how to formulate your question to build upon something the witness has already testified to. Or that you can use to lead them into testifying to something that they haven't testified to. That's the other mistake a lot of newbies make, is they think that on cross-examination they cannot get new evidence into the record. That is incorrect. However, what you cannot do is start out in left field to do that. Okay? You have to start leading the witness to that point by building upon something they already have testified to. Okay? Now, there's multiple things you're going to want to address about what they have or have not testified to up to this point. Number one, if they testified to a fact element and that fact is working against you, you need to rebut that element. If they didn't testify to an essential element, and how many essential elements exist in an offense with 7 elements, guys? How many of those elements are essential?
Seven.
All 7 of them are essential. If there are 7 elemental components to an offense, the state must assert and prove all 7. They cannot prove half of them. They cannot prove a majority of them. they must assert and prove them all in every single charge. Anyone not understand that? If there's 15 freaking elements, they've got to assert and prove all 15. Now, how do they assert the charge? They must do two things to properly assert a charge. The charge, if they wish to make sure they've covered all the elements, must essentially mirror the language of the statute, at least in the way that the allegation itself is worded and made. And the allegation must contain specific facts that tie the accused to the act that supports the element. There has to be enough factual information about the accused committing the act in with the act itself in order for them to charge the offense. Now, can anyone tell me why that is, or why they think it isn't correct?
Well, the complaint's based upon their cause of action or their
Well, in this case, in Jane's case, the complaint is based on what you see right here in orange.
Yeah, it says the owner of any animal in the city. Now, did they determine that she's the owner of these animals? I mean,
well, again, they're charging her under 680 E1. Now, remember, E cannot exist without everything that's in this top portion up here.
That's right.
Okay? So how many elements of the offense exist just in this first paragraph?
3.
3?
We have at times, including conduct that creates a public nuisance. Well, that's 1. Making a false claim that the party owns an animal. That's 2. Commits an offense by act or admission or possession. If he or she allows the animal to create a public nuisance, well, you know, one man's nuisance is another man's liberty, right? The following are public nuisances. Oh, really? Do they have a complaint from somebody in the public that the condition that was established or condition that was observed or witnessed was creating a public nuisance to her?
They have
neighbors?
a complaint. What they don't have is the actual elements of any of the offenses they've chosen to use for this.
Yeah, I'm trying to remember this. This was the case where the neighbors complained. Is that correct?
Correct.
I mean, this has been like over a year. I think the last time I was on one of your calls.
Well, it was March something.
March of this year. Okay. All right.
Yeah.
So,
but in any case, hold on just a second. The first sentence of the first paragraph has 4 elements in it. 4. Can anyone identify what those 4 elements are?
We have the owner, we have the city, we have behavior, and we have conduct.
Behavior and conduct are synonymous. But you're still missing the other one.
And public nuisance.
Nope.
Owner, animal.
No, the conduct can create a public nuisance, okay? The list below is the public nuisances. We haven't got to what constitutes a public nuisance. But yeah, owner, animal, in the city, okay? And behavior or conduct. Owner, animal, inside city limits, behavior and conduct. Okay? Those are your 4 elements in the very first sentence. Then you have everything that's in E. A person, in this case, an owner commits an offense. Not just any person, an owner commits an offense. Okay?
Yep.
If he or she intentionally feeds any animal or makes food available for animal consumption in a manner that creates a danger to public health or safety, destroys public or private property, or causes more than 10 adult animals to congregate in one location at the same time. They are shooting at this current time for E1. Okay? So, we have 4 elements in the first sentence. How many elements exist in E? And person is the same element as owner. So don't count that as a new element in E.
Well, describe the nature of the danger to the public health and safety.
No.
What is that?
Stop. I'm asking you a simple question. How many elements exist in the E portion of this ordinance? That's it. That's the only question I need you to answer. Read it and tell me what constitutes an element that must be asserted and proven.
Well, first off, the person
I
was
just
the
told
owner.
you person and owner are synonymous in this ordinance. So it's not a new element. Person is not a new element. It's the same element from the first sentence. The owner.
Okay, well, the offense.
The offense is not an element. The offense is the result.
Well, then the term intentionally, if he or she intentionally,
Intent is an element.
Creates a danger.
Do you see create danger in there anywhere? In E?
E1.
Yeah,
Well, that's not E, is it? E. Look at E. Only part E.
Yes, there's no danger to public health and safety.
You've got intent. What else?
Make food available.
Feeds or makes food available.
For animals to consume.
In a manner that.
In a manner that. Okay? So, intent, feeding, and availability of the feed in a manner that. So that's what? How many elements?
4.
Okay?
Now, if I may, the E is really not correct. A person commits an offense.
I know it's not correct. That's the way that's the way it is in their ordinance. This is an actual copy of their ordinances. Okay? All right. So, that gives us a total of 8 elements so far. Now, number 1. How many elements?
3. Creates danger, public or health and safety.
No, there's 4. Creates
Yeah.
danger, public health,
Public health.
or public safety.
Safety. Yeah, 4. Sorry, 4.
Okay, so that's a total of 12. So there are 12 elements they must assert and prove. Okay? Now, let's look at the complaint. Did intentionally feed an animal or made food available for animal consumption in a manner that creates a danger to public health or safety in violation of this section. But guess what isn't here? There is absolutely no details as to how this offense was committed.
Yep.
Other than just saying they fed them.
So now they have to prove every one of those elements.
They have to prove them anyway. But notice they did assert that it was Jane on this date. Okay? There is no time, but there is a date. That it occurred before the making of the complaint. And that it was done within the territorial limits of the city of Irving. So in the city from the first sentence is covered. As is the name of the alleged person. What they haven't asserted anywhere in any of this is that Jane is the owner of the animals in question.
Absolutely. Yep.
Okay? They also did not specify what specifically the manner of feeding was that was unlawful, nor did they specify a specific danger to any public health or safety. So in other words, that creates a danger. Okay? The problem here is what is the tense of that creates?
Well, it's in the present.
That's exactly right. It's present tense. It must have occurred right then and there. Same thing would have applied if it says that created. The danger would have had to have occurred right then and there as a result of the feeding. There is no could. There is no may. There is no potential. There is immediate. It is present tense.
Or shall.
Well, no, shall would be a command that creates a duty. So that shall create a danger. That would be ordering her to create a danger, which it can't do. Okay, now everybody understand what they've got to assert and what they've got to say in the complaint. They've asserted all the words from the ordinance in the complaint, but they haven't attached any specific facts to them that specify how that particular element is supported by the facts. And that's one of the reasons we're arguing that the complaint is insufficient on its face. It's legally deficient to charge an offense. It doesn't specify how she fed them that was allegedly unlawful, or how it created a danger, or what that danger is.
I have a quick question.
Okay.
Have you seen a complaint, maybe from the state of Texas?
This is the complaint.
Right. But have you seen a complaint that actually addresses all elements?
Yes.
Okay.
I wrote 482 of them against a prosecuting attorney.
No, from the state.
I have, but they're usually for much more serious offenses.
Right.
Those they want to get right.
I find them extremely deficient, the ones that I've seen. But.
Which this helps me out right here, even for mine, because now this gives me another element to argue in my pretrial motion. How to set it up. Oh, well, the complaint is completely deficient on its face, and here's why.
Possibly so. If it doesn't give any specific details that links you to the act, see, the only details they have is Jane's name and a date. That's it.
Remember, mine was about a defective equipment headlamp that didn't exist in the law.
Well, a defective equipment allegation that doesn't exist in the law. Remember, words matter. Okay? But as far as identifying Jane as the person committing the act, that right there is the only two things that tie Jane to anything dealing with the ordinance. Okay? There's no time, and yet the complaint is required by law to specify the as near as practicable or possible the date and time of the offense. There's no time listed here. At some point during the day, she did this. We can't tell you when it was, though we can guess it was about sometime after sundown, because it looks kind of dark out in the video. But that could just be bad light filter. Could be a bad lens. Could be a dirty lens. But regardless, they're missing a lot. Hence the reason why we went directly after the complaint as being insufficient. So, given that, as I've tried to explain to Jane, and as we've been practicing in class, the only thing you have to do is show that they did not prove any one of these 12 elements. The more of them you can prove they didn't prove, the better. Okay? But it only takes one. Okay? Now, fortunately for Jane, she seems to think it's a detriment, when in fact it's the best piece of evidence she could hope for, is a video from her neighbor's Ring camera, or at least some kind of camera, that recorded exactly what happened as far as 3 cats eating out of 3 different plates. But
Actually, it was 2 cats. One cat was sitting in the flower bed.
well, just sitting in the front. But either way,
Yeah.
wouldn't make any difference. As long as it ain't more than 11 or more, it doesn't matter, does it?
No, it doesn't, but that's not even in the charge anymore. But one thing is, I got 5 motions for pretrial to do Tuesday. I'm not even getting to all this stuff right here, I don't think.
All right, let me get in here. All right. So, Irving. Okay. All right, can everybody see this video?
Yes.
Okay. Now let me just make sure you can hear it too. All right. Now notice, right here is cat number 1. Here is cat number 2. And I think this is cat number 3. Right, Jane?
Yeah, that's my cat, Handsome, the one in the flower bed.
Now, that's the entire video.
No, it's not either. You see me come out the door, put the food on the ground, unless y'all showed it before I got
never
here.
mind. There it is. Never mind.
Here. Come here, you little fool. Come here, fool. Here. Hey, put that cat down. Handsome. Handsome. Handsome, come here. Handsome.
So you're actually calling the cat out here in the flower bed.
Yes.
Okay. But notice, Jane walks off the screen. I'm going to pause this for a second. Jane walks off the screen in the lower left, and you hear a clack. Now, that clack could be a front door, or it could just be her smacking her foot or the bottom of her shoe on the porch. We don't know, because we can't see Jane, can we? Can't see the front porch, can we?
Nope.
So don't offer them anything to the contrary, Jane. You understand?
I won't.
All right. So, given that, let's watch it to the end. And this is about halfway right here. Now, this is approximately 8:29 at night. All right, that's it. Now, pop quiz. Who can identify the danger to public health and safety in this video?
Oh my God, the various numbers are just over the top. This is just outrageous. She should be strung up by her fingers. Public safety? Sorry, I don't see any.
Number one, the cats are on private property.
That's right.
Number two, there is no member of the public anywhere near them that we can see in this video.
Yeah.
Number three, there is no apparent danger in this video. Nothing that they can prove danger about anyway.
Yeah.
Absolutely nothing. Now, the citation, I believe, says unattended feeding. Correct, Jane?
Yeah, unattended feeding, and it says
Okay.
feeding.
But again, notice in the elements of the ordinance, unattended feeding is not a thing.
It's her property.
Okay?
It says
So,
particulars are feeding feral cats and wildlife, or leaving food out for them.
again, there is nothing in the ordinance that says a damn thing about where the animal comes from, other than you have to be the owner of the animal. Even the way the ordinance is written, okay? The way this is written, there is nothing in here that says these animals are wild or feral. Not a word.
Yep.
You see that?
So if you, I'm a little confused. If you're the owner of the animals, how can they create a law to prohibit you from feeding them as an owner?
Well, that would be a good question. But it doesn't
On
really
your
need
own,
to be because they
on their
can't.
own property, on their own
Exactly.
property, on their own property.
Okay, I'm really baffled right now.
But notice, again, there's nothing in the ordinance either that says whether the feeding must occur indoor or outdoor. So this ordinance could be used against you for feeding them in your kitchen just as much as it could be used for feeding them in your front yard.
Wow.
Yeah. Also, there's nothing in the definitions. It does describe owner, and it can be several different things, but like harboring and
Again,
maintaining.
Jane, they don't have any evidence of you being the owner.
No, I know they don't.
There's nothing that they have that proves that you meet the definition of owner in their ordinance.
Right.
Okay? The only part you need to remember is that the person down here in E is actually the owner from the first sentence.
Yeah.
Okay?
Yes.
Otherwise, this can be any animal fed anywhere at any time in any manner, and they can still use this ordinance against you.
Yeah,
Which is why we challenge the ordinance as being unconstitutional for being vague, ambiguous, and overbroad.
Yeah. Could be hummingbirds, squirrels, birds, anything.
Because this ordinance, the way they're using it, they can charge you for having a hummingbird feeder, a bird bath, a squirrel feeder, giving your dog a treat while you're training them on a walk. Hell, for all we know, they can use it when you give it to your kids if somebody calls them an animal.
It's any non-human, not invertebrate. That's what it is.
Okay. The point being, they can't. The ordinance is invalid on its face.
Yep. But she's still doing it anyway.
Okay. And the thing is she knows she doesn't have any of the elements that she has to prove. She has no evidence supporting any of them. And yet she's proceeding with the prosecution anyway.
Well, she can't stop now, can she?
She could if she was smart, but she's a city attorney, hence she's not smart.
Right. Well, they're delaying, they're getting sued. That's what it is. They're delaying that.
No, what they're doing is increasing the payout.
Mm-hmm.
Okay.
Because the longer they let this go on and the more they inconvenience you, the more money you can ask for.
Oh, I spent this whole year working on this, and that's about all I've done this year. Not making no money or nothing.
Well, I hope you've kept track of all your time, your mileage, your
No, I
parking fee.
haven't. The mileage is no big deal. I'm 2 blocks away from where they are, but I'm not, because I wake up in the morning, I start working on this, and I go to bed at night, and I'm still working on this. That's what I do most of the time, so it's pretty much all the time.
Well, again, that part's not going to get you money, Jane. The fact that you have to fight your case yourself because you don't want to hire an attorney is not going to be what gets you paid. What's going to get you paid is the malicious prosecution and the harassment by constantly calling you into court for hearings with no outcomes.
Mm-hmm.
Okay? That's what's going to get you paid.
And that's consuming your life energy, your lifetime energy, which is now in direct correlation of some type of remuneration that you need to be compensated for,
Well, you
because
have emotional distress claim out of this and everything else because it's a criminal prosecution. Doesn't matter that it's for money only. The fact is they have hounded and harassed you for almost a year for an offense they knew they didn't have any evidence of.
This is the second one, remember? So it's been 2 years already just for this.
I got that, Jane. I'm just saying, you screwed the pooch on the first one. You paid the motherfucker. Okay.
No, I never paid. It never has been resolved since I.
Well, again, either way, until you go back and get the jurisdiction challenged on that, the way subject matter jurisdiction challenged on that, and beat it, it's there. There's a judgment on it. That's the problem.
Yeah.
Okay.
Yeah. But overall, it's been 6 years that my neighbors had me in court because
Jane, okay. Look, you cannot wrap 6 years into this, Jane.
I know.
Well, then stop going back in time.
Not you.
Okay? Focus on what we're talking about right now. Right now, this is the case. This is the only thing that you've got a claim to, as things exist right now. You got it?
Yes.
So stop worrying and adding in and talking about anything else because it doesn't matter.
Well, what about the fact that this one's going to be challenged and they're going to overturn it, and then the other one should be? I have to challenge it too, or it's not going to just make this one that one?
No, this one has nothing to do with the first one, Jane. They're not joined at the hip or anything.
All right. Great.
You're going to have to file a petition to a higher court to overturn the judgment because of lack of subject matter jurisdiction. And then you're going to have to show how they never acquired jurisdiction because there was never an offense. And even though you challenged it, they refused to stop the prosecution. The problem is how did they win that case, Jane?
Because you threatened me of charging me with a higher offense, and so
That's not the answer to my question, Jane. How did they win?
I gave in.
Correct. And that is what creates your biggest hurdle in going back and challenging it. Which is why you need to not be focused on that one, because that's a hurdle I don't know if you're going to be able to clear.
Really?
It's not that it's impossible. It's just not very probable based upon the circumstances. If you can prove coercion, that's one thing. But if you can't prove it because she didn't offer you that deal in writing or make that threat in writing, then you've got a harder row to hoe, don't you?
Yeah, but I had the recording, remember? Yeah, go.
You recorded her threatening you with a higher offense?
It wasn't necessarily. I sent it to you before. It wasn't necessarily a threat. No.
Well, if you don't think it's necessarily a threat, how are you going to convince a higher court that it was a threat that coerced you, Jane?
I gotta go back and listen to it. I perceived it as a threat.
And it's conversations like this that are what make me believe that's going to be a hard one for you to overcome.
I haven't focused on that case in a long time, so. I gotta go back and listen to it again. I sent it to you though.
Still beside the point.
The oral.
Okay. So
Ordinance.
now, real quick, this is what this city attorney has done in this case so far. All right. This was the original complaint, and they put the entire ordinance in this, except for the first paragraph at the top. They put all of E1, 2, and 3 in this one. Okay? Then they told us that it was perfectly fine the way it was after we challenged it, and they said there's no problem with it. It's just fine the way it is because it does everything the statute under 45A point, whatever the number is now, says it has to, blah, 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 blah. And yet, despite swearing up and down it was sufficient the way it was, this is what they did next. They sent it back to this, which took out everything except it didn't specify which part of E it was going after. So essentially, it was less words, but it still charged the exact same thing as the first one, which was all of 680E.
Wait a second. We have two different applicants here. Are you telling me that
Doesn't matter. They're both court clerks.
Yeah, it's not a real applicant.
Well, okay. Based upon a report to me by Nathalie Gramindo Delgado, animal control officer. So when did Nathalie Gramindo
Via
Delgado?
citation.
That's all.
They're basing it off of the citation she filed in the court.
She didn't investigate or anything.
Okay, so is that citation signed under penalty of perjury?
The citations are never signed under penalty of perjury.
Okay.
All right. Now, this was the second amended complaint. After we responded to the original complaint and the first amended complaint, making the exact same arguments, they turned around and filed this complaint. Even though saying there was nothing wrong with the other two, they filed this one. Now, can you look at this and tell me what is wrong with this one?
Same thing.
No, it's not the same thing. Not by a long shot.
Oh, wait.
Causes 11 or more adult animals to congregate in one location. 11 animals? Wow, I thought it was 10 animals.
It's more than 10, hence 11 or more.
Okay, well, I only saw 3 in that video. I don't see how they can have a substantiated claim.
Well, again, you got to remember, this has 3 separate charges in it. What is the problem with this complaint as it's written?
Hasn't identified the owner. Hasn't identified the danger to public health. Hasn't identified the danger to safety.
Okay. But just based upon the words that are there, read this. Did intentionally feed an animal or made food available for animal consumption in a manner that creates a danger to public health or safety, destroys public or private property, or causes 11 or more adult animals to congregate in one location at the same time in violation of 6-80E1 City of Irving Code of Criminal and Civil Ordinances. What is wrong with that paragraph?
One is only charging the first part of that.
Correct.
Yeah.
So they've got 2 and 3 in here, but they're only alleging E1, and thus the complaint is invalid because it's charging 3 offenses, but citing only one part of the ordinance to support it.
Correct.
So it's still charging the exact same thing as the first one and the second one. It just still isn't wording it correctly.
Yep. Oh, it's just a slight typo. Yeah, right.
All right. And then they turn around and they filed the third amended complaint.
Last Friday.
The public danger. Crazy.
Let's see, April.
October 31st.
This one here.
Nuh-uh.
Okay.
Oh, wait.
Uh-huh.
That is.
And now, it actually says 680E1 and only lists 680E1. Okay?
Yep.
So now, as far as actually stating the charge as it appears in the ordinance correctly, they finally did that, but they still have no supporting facts to go with it.
Yep.
And the one they're still missing is the ownership requirement.
Yep.
Okay? So, either way, still gone. Now, can anybody tell me the problem with having to challenge the form and substance of a criminal complaint in the state of Texas? What is the biggest thing you have to avoid doing when you challenge the validity of a complaint, either through form or substance or both?
Admitting anything.
Say again?
Admitting anything.
Doing it without incriminating yourself.
Yeah.
For instance, do you know how many people I've seen challenge these in writing and say, it didn't happen on the 10th, it happened on the 14th. I know because it was 2 o'clock when I looked at my watch when I was doing it. Okay? The problem is if you go through in detail everything they've got wrong, then and tell them what the correct thing should be, then you are confessing to specific elements of the crime. Okay? So you got to be very careful to remain generic yourself while still making a clear enough argument to say, here is why the complaint doesn't work the way it needs to under law. It's like, did y'all see that episode of Judge Judy where this little black girl is suing these two black guys for stealing her wallet, her bag, her iPhone, and her earbuds for her iPhone, her AirPods, and she sued them for everything that they took. And she's listing, and Judge Judy asked her to list off all the things that were stolen, and she's sitting there making a list of them. And one of the defendants goes, Judge, I'm sorry, Judge, but they wasn't no something or other in there. And Judge Judy just busts out laughing. She can't help herself. Okay?
That was an indirect confession.
Exactly. But that's the problem. That's the kind of shit most people wind up doing when they're trying to go and fight the validity of the complaint. Yep. It's what they usually wind up doing when they're getting interrogated or stopped at the stop initially. They say way more than they ought to, which is why Craig's rule of traffic stops. What do you say to the cops?
Nothing.
Absolutely nothing. You shut up, you keep shutting up, and when you've done that, you shut the fuck up some more. Okay? So, Jane, once again, I'm going to ask you.
Uh-oh.
You say that list of questions for your cross-examination keeps getting bigger and bigger and bigger. My question for you is why?
It's not now.
You have this paragraph up the very top. You have E and you have 1. Those are the only things you need to be focusing on with your cross. That's it.
I know.
Everything else the prosecutor will take care of putting in place for you to build from.
Yeah, I need to delete all the stuff about the other 2 offenses.
Okay? So don't delete it. Just move it to a different document and get it out of the one you're going to use in case they change the complaint yet again.
All right. It's too late for that.
That way you don't have to go back and rewrite the whole damn thing again. And I'm going to give you another little clue about something I know you're not doing. Every time you make a major change to a document, save it with a new version number. Don't overwrite your document every single time you change it. Keep copies as you progress for exactly this reason. So if you change your mind and need something that you went back and wiped out, you haven't lost it. It's still there in a previous version.
Well, I still have all the hard copies too, but I know what you're saying.
The hard copy is not in your computer, Jane. It's not editable in hard copy form, Jane. It's
It
not,
is in
you
my
have to.
They're in my computer.
Not if you're saving over them every time you change them. They're not.
Are you saying that I did that? No, I don't. What I do is I save as. I save a new file as. I don't save over the one that I just modified. And actually, they're your documents. The motion, those motions were. But so I save as a new document. So the old ones are still there.
Well, I recommend you give them version numbers so you can keep up with them.
All right.
Okay. So, do you have any questions on what you need to be doing with this, Jane?
Not this, because I'm not going to be doing this on Tuesday. I mean, because I'm trying to focus just on what I have to do for Tuesday.
Which is?
My, first of all, the motion to quash, the supplemental motion to quash, request for evidentiary hearing, and motion to suppress, and then motion to eliminate, and then inability to pay. Inability to pay. All those I have to.
Well, you start with your inability to pay.
Oh, you start there? Okay. I would think that that would be the last thing since.
Jane?
Okay.
Start with your inability to pay. Get that out of the way first and foremost. Don't piss the judge off with everything else you're going to be doing. Deal with the inability to pay and get a ruling on that first.
And
Got
then,
it?
Okay.
Then you can fuck everything else up.
No, I'll fuck it up.
Well, good. Glad to hear it. I will, for one, would be extremely happy if you don't.
I won't.
Now, do you remember how I showed Helen how to make the arguments? 2 pages. The area you're talking about, the notes, which should be summary points from your motion.
Yeah, it is.
Don't just read the motion.
I know, I'm not. That's too long.
Okay? Make your outline points, and then make the notes that go to those specific points, and put them in a book, back to back, like so. So when you flip it open, your points are on this side, or your subject is on the left side, and your notes are on the right side. And you go down that list of notes talking about that thing. When you flip the next page, same thing. Your subject should still be listed on the left. Your notes for that subject should be listed on the right. That will keep you focused. It will keep you on point. Don't deviate from that. Just make sure that you touch on all the specific required points from your motion. Okay?
Okay. So now on the case law that's in the motion from the specifically for the motion to quash and the supplemental, do those need to be printed out as far as the whole cases, or just a citing out of the case? that I make copies of to give them.
You can bring copies of the case to court and hand them out.
But does it have to be the whole case? Can it not just be sightings?
It has to be the whole case if you're going to give the court a copy of it, Jane. It can't just be the little piece because that's not the case.
Okay.
That would be me like asking you, would you like a new pair of shoes? And I bring you one fucking shoelace.
So every case that I cite and any emotion I have, I have to bring
If you're going to present a copy of it to the court, it needs to be in full, always. There's nothing that says you have to give the court a full copy of the case unless you think they're going to ask questions about it.
Well, they wouldn't have read the motion, you know, so they need to see something.
Well, again, if they didn't, that's a separate issue that you can deal with. But if they have and they have questions about it, always better to have a copy of it in hand than not. And you need to have enough copies to go around. It's like gum in school. If you don't have enough for everybody, don't bring it.
And Eddie, if I go to Tao of Law, I can find the information to sign up for your classes. So I can, it was just
No, if you go to the logosradionetwork.com,
okay,
you can do it there. That's the easiest way, but there's links in this email you're about to get. There's links you can follow to get a subscription. So hang on just a second.
I'm not included in that email because I was just invited tonight as a guest.
If you want to give me your email address, you can be. Just reply. Does anyone in this class have your email address?
Yes, Thomas does. But
Thomas, are you subscribed to the class? No, Thomas is not subscribed to the class, I don't think.
I can send you a chat with my email.
If you want to send it just to me where not everybody has it, then do that.
Yep,
You can do that right here on Zoom.
Yep, I'm going to send it just to you.
Okay.
Thank you.
Yes, ma'am.
Are you gonna have the link? Okay, it's gonna have the public photo on that with this video too.
Right, I sent it. Thank you.
Okay. All right. Let me add you to the contacts, and then I'll put you. Why does your name sound familiar? You're in relation to that. What's her name, Regan, that does the YouTube videos?
Oh,
likely not. I'm a farmer in the High Sierras in Northern California.
You're thinking of Regan, the case?
No, Chris Regan, I think, is her name.
Oh,
no. I'm dealing with property rights issues and code enforcement in California.
Alright, you're now in the contacts. Let me add you to the list here. Alright. Alright, once again, everybody check your email.
nope, I don't have it. Let me see.
I'm looking in junk right now.
I'm looking in junk too. It's not there. I don't know what's going on.
Maybe my name. Hold on.
Look at all mail.
Found it in my spam class here.
Yep,
Or
it was in my junk.
It wasn't in my junk, but I checked all mail and it was there. I don't know why it's not in the inbox.
I did not get the one earlier today, but I did just get this one, Eddie.
Yeah, I got it
Okay.
too.
I don't know why it does that from time to time. It shows on my end it went out at 10 something this morning, 10:32 or something like that. So I don't know why nobody got it, but okay.
Okay, great. Thank you.
All right. All right. Anything else?
Excellent. Thank you, Eddie.
Yep. And please, guys, if y'all like what we're doing in this class after you've been to it once or twice, please invite other people to come to it. It's better to be prepared before you got a problem than have to try to learn it on the fly during the problem.
Yes. I can vouch for that.
Okay?
I can too.
All right, wonderful. I look forward to the next one, and I'll sign up in the next few days.
Okay. All right. Well, they are every Thursday at 7 p.m. Central Standard Time. Like I say, unless it's a week that's got a major holiday in it, it's every Thursday. If I have an issue where I'm not going to be able to make the class because the power failed me or the internet's gone down or something, then I will try to get in touch with somebody that can let y'all know why I'm not on class or doing class that night. Because if it goes down, I can't email anybody or the class and tell them we're not having class because. So I've got to get somebody else to cover that for me while I'm blacked out. It doesn't happen often, but often enough that it's why I haven't been on the radio show worth a damn. Because it can happen any time of the day or night, and it usually does. Okay? All right, guys. Well, y'all have a... What's that?
Dark Ages.
Yeah, feels like it sometimes. Anyway, y'all have a great night. Thanks for being here. Have a good weekend, and we will see y'all next Thursday, 7 p.m., all right?
Yes, sir.
Great.
Thank you,
Thank
Eddie.
you.
Yep.
Thank
Night,
you.
guys.
Night.